Subtopic. Bismillahirrahmanirrahim. Thank you very much for having us in this interactive session. And before coming to my topic, I would like to say that the opinion rendered by different persons, by different speakers in this interactive section were very enlightening for us. And I have observed in this session that a lot of work has been done on mediation and other things in this part of the country, that is Karachi, Lahore, and Islamabad. But we represent a society which is indeed a war-torn society. And whatever has been done, it was not alone by the judiciary, but there are certain other institutions who are also working on these subjects. And I really appreciate the work of Naveen Merchant and Ms. Haya on this particular subject. And through this podium, I would also request them that they should also extend their expertise to the province of Khyber Pakhtunkhwa and the province of Balochistan. Now, coming to the topic. The topic before me is the frivolous and vexatious litigation. Frivolous and vexatious litigation is, I think, is known to all. The frivolous litigation is commonly understood in our society as a litigation which has been initiated without a probable cause or even without a sustainable cause. But it is very difficult to define this frivolous litigation. Whether the litigation from when inception was frivolous or after the conclusion of trial it became frivolous, or likewise whether it was the litigation which was launched by a person, it was a frivolous, or sometime we see that the defenses are also raised frivolously before the court. I was pondering that what were the main causes of initiation of these frivolous litigation. My conclusion are there are two main reasons. One is capacity, lack of capacity, and secondly is lack of legislation on the topics. So what is the lack of capacity? The capacity in this particular area, we have a trioca. The trioca of a lawyer, the judge, and the litigant. So we have first to educate these three stakeholders. How to educate a lawyer? Why the lawyer is bringing a frivolous litigation before the court? Either he does not know the law or he is intentionally doing it. The first thing when a case comes to a lawyer, he has to choose a forum. For example, in number of cases when contractual disputes are involved, there are arbitration clauses and they are filing a constitutional petition. The second responsibility is on the judge. When a particular list is brought before a judge, he has to evaluate the list. He has to see whether it was maintainable. But what we do normally is, for example, a senior lawyer is before the court. Normally we say, okay, notice to the other side. And after an year, it transpires before the court that the court had no jurisdiction. Now we do not have a mechanism to curb this kind of practices. And this requires, I think this requires legislation. In our country, I don't think that there is an effective legislation on this particular area, except in Islamabad there is an act, but it is not exhaustively dealing with the matter. The legislation, there should be, I think my suggestion are there should be a legislation regarding curbing or at least reducing the frivolous litigation. For example, in some countries, we do have a legislation, more particularly relating to the vexatious litigation. There are certain jurisdictions where the person who is litigating vexatiously they are declared as vexatious litigator. And when they filing a suit, they are, when once they are declared as a vexatious litigator, they then, whenever they are going to bring a list before the court, first they will have to seek leave of the court. So we do not have any legislation on the particular subject. Yes, very true. I think there is inbuilt provision under the Code of Civil Procedure, and there are certain inherent powers of a particular court when entertaining a particular petition. For example, in CPC there is provision Order 7 Rule 11 CPC. So when a list is filed before the court has the ample power to evaluate whether the list is sustainable, whether it discloses at least a sustainable cause of action to proceed with the matter. And if the judge is of the opinion that it is not sustainable in the eye of law, then it can reject the plaint, can order for rejection of the plaint. And very true, yes, there should be certain protocols, and we have even the respective high court. I think in Peshawar High Court we have made certain amendment in laws. For example, the pre-trial proceedings, notices, case managements. We have also made efforts by amending the Code of Civil Procedure, and I think that yes, it is true that there could be SOPs, there could be a protocol, there could be protocol for curbing that particular